I promised we'd start on time, so we will. It's my pleasure to introduce Sheila Block, who I'm sure is well known to many of you as a senior litigation counsel, partner at Torrey's, outstanding advocate, outstanding advocacy teacher, and someone who you may have run into in advocacy teaching over the years. I also promised Sheila I'd keep her introduction short, so I will now turn the microphone over to her.
Thanks, Wendy. This has the feel of the last episode of Survivor. You folks have had 2 long days, and you've taken the better part, though, staying for the cleanup batter, who is a terrific speaker, and I know you'll enjoy listening to Ian. In the meantime, you have to listen to me for a few moments talk about alternative dispute resolution. And you may think that alternative dispute resolution, especially the mediation-based dispute resolution, is to trial lawyering what passing and dribbling drills are to basketball. They're connected, but not the real thing. But in fact, the skills of the trial lawyer are valuable tools in mediation and arbitration, and in the interesting combinations of both that we are starting to see. Now, there are those who would disagree. They would say that the attitudes of a trial lawyer are inimical to the goals of mediation and the aims of no-nonsense arbitration. But if you can be a different lawyer in different situations, if you have the capacity to really change your approach and your style in differing advocacy situations, then you have the capacity to really add value in ADR, using many of the same skills that you use in traditional litigation in the courts. Now, being different in different situations is very much the trial lawyer's skill. I heard a psychologist, Dr. Gordon Zimmerman, talk about how trial lawyers, along with actors, salespeople, TV evangelists, people of the like, are what they call high self-monitors. Now, a high self-monitor is somebody who can change for the situation. And he gives the example of the fellow going home to his wife, and she says, "I just don't know who you are anymore." And he says, "Who do you want me to be?" Well, it may not be the best attribute for domestic bliss, but it certainly is an excellent tool when you're going from JPs or provincial court judges to the variety you get in the Superior Court, all the way up to appellate work in the Supreme Court of Canada. Being able to be an advocate in all those situations, you will add value in ADR. But we have much more to offer than our high self-monitor natures. Let me start with mediation. Now, traditional lawyers would say, if you've got a strong case, don't mediate. Now, I tried this proposition out over the last month or so on some mediators and academics in the dispute resolution field. And the first response I got was, this is a typical litigator's attitude. Subtext here is, you're not as subtle or mature enough to understand what we do. And I suppose there's probably no arguing with that. The second response I got was that a skilled and knowledgeable mediator will actually use the weakness of a case aggressively to convince the party that she ought to settle because she has a weak case. So one of the first points we have to get in our head as litigators is we may have to shed some of our prejudices about mediation. It's fine for some things and some people, but if you've got a good case, run off to court. So we might have to reconsider that proposition. And the biggest impetus for reconsidering that proposition, of course, is our clients. Clients don't want to engage in a process that we can't say how long it'll take, we can't say how much it's going to cost, and we can't say what will the outcome be. They would prefer to have all of that under control, as well as have some participation in the outcome, be part of the resolution instead of just handing it over to another party. So it's a very attractive proposition to clients and very attractive to business people in these days. So I looked at 3 types of mediations to look at the kind of advocacy skills that we could bring in those situations. The first is the evaluative mediation, and that's very similar in substance to what we do traditionally. Although you need to adjust your tone. George Adams has recently written a paper that I'm sure many of you have seen that's cited in my note, where he talks about the advocacy and the manner of advocacy that's effective in mediations. Part of the task that you're performing in an evaluative mediation as counsel is to show the mediator and the other side the strengths of your case, to contextualize and soften the weaknesses of your case, because the mediator is going to be making some finding in an evaluative mediation about the rights, making some evaluation of it. So you prepare in a similar way to preparing for a court case. You make similar points, although you have to change up in terms of your style and tone. And you recognize, of course, that the end game is resolution between the parties. So you must assist in the process, not impede. But there are lots of opportunities to deploy the skills of a trial lawyer in mediation. In the evaluative mediation, it's well suited to our skills. Who to pick in those kinds of mediations? Often you will go to the retired judge or the practicing lawyer because they, like we, think in terms of the rights and wrongs of things. The second type of mediation is the facilitative or problem-solving mediation. The theory here is the parties jointly share a problem. They need to be creative. They need to communicate better. They have to consider their needs and interests, not dissect the past and lay blame. The parties obviously have to be very active in the dialogue in this type of mediation and take responsibility for the solution and understand each other's aspirations. What, you say, does a litigation lawyer have to do with this, unless social work is your hobby? And in fact, it's less than you would have to do in an evaluative mediation, but you can still play a useful role. In this type of mediation, the parties are generally upfront in terms of the discussions. They will do a lot of the talking, but the lawyer can step in, prop up a faltering client with by giving voice to the feelings he's trying to express, by adding eloquence to his awkwardness. And to do this, you have to prepare with your client to find out what they really feel about the matter, what their motivations are, and that is useful in trial work. Sometimes we don't get that far. We're too busy lining up the rights and the wrongs, but this dimension is useful in trial work as well. Now, the mediator you'll get in this kind of a case will be different than your retired judge, typically. You'll want somebody with the skills of mediation that can cause this better communication between the parties. Now, theorists, there's some theorists who say there's a third type of mediation, transformative mediation. And whether this is a separate type or a stage which can be reached in any mediation, we don't have to sort out here. But the theory here is that the mediation itself transforms the parties. They recognize and accept the other side's story. Now, this is a good discipline for the trial lawyer. John Stuart Mill said you should know your opponent's case better than your own. It's a strange role for a lawyer or an advocate to be in, however, in a transformative mediation. But you can still help. Often, or sometimes, I should say, the transformative event is an apology. And the lawyer can craft the apology, can set it up, can deliver it, and can also be helpful in figuring out the solution. Now, on the rare occasion, if you're setting out to engage in a transformative mediation, which I think we would rarely be, but if you were, it's used a lot in community mediation, so if you were putting in a group home for developmentally handicapped people and you had the community up in arms, you might hope to engage in a transformative mediation between those factions. So it's not likely to be the daily bread of this crowd, but in any event, you might want to turn it over to some kind of mediation specialist, an Alan Stitt or a Christine Hart or Debbie DiGirolamo or Michael Silver, or somebody who actually does mediations as a full-time diet. I see that Mike Wadsworth has now joined Alan Stitt's office. Mike was the former athletic director at Notre Dame, and he should be well placed to mediate almost anything, having brokered between the Holy Cross Fathers, the Notre Dame alumni, the national press, including Sports Illustrated, and the Big Ten refs. I think there's nothing we can't throw at him that he hasn't already seen. But in any event, for that kind of mediation, you might want to step aside and stick to your trial lawyering. The preparation you would do for mediations would be very much like the preparation you would do for trial lawyering. You would figure out what your good facts are, what your bad facts are. You'd develop your themes and theories. You'd figure out how to contextualize your weaknesses, and you'd work on solutions for resolution that you hope will emerge. And all of this is done in your traditional advocacy practice. So it's familiar territory, and you can be helpful in these situations. Let me turn to arbitration, because this is more closely aligned to the litigator's traditional work. And apart from being obliged by contract to arbitrate, choosing arbitrations are really three main reasons. You can pick your decision maker. You can choose to make it not binding, and you can keep the proceedings private. None of those luxuries are available in the court system. Of course, in the court system, you don't have to pay for the judge or pay rent on the room, but the large issue of picking your decision maker is what often sends litigators into the arbitration field. Now, sometimes the choice of the arbitrator is easy. Both sides know they want a particular person and they agree to it. Other times, the view on the who question is very different. One side may want a black letter, legalistic judge. The other side may want palm tree justice. And so then the debates are extremely lively on how you're going to figure out who is going to decide this. One elaborate process that I'm aware of in a major international commercial arbitration involved both sides picking three neutrals, picking an American, a Canadian, and someone from somewhere else who would be the chair. And the idea was that each side would list 10 names for each of these positions, hoping that there would be a match in the corresponding lists. For each list, an immense amount of research was done on all of these people all over the world, what their decisions were, everything they'd written, and so on, their background. And no matches after 2 rounds and many dollars of time and effort spent. So in the end, one party just took names off the other side's lists. Now, you might think that this was a dumb thing to do for that party, but in fact, in the end, those 3 that were picked from the respondents' lists held in favor of the applicant. And the fact is, when you're proposing arbitrators and picking neutrals, you can have ideas of their tendencies. You can guess the way they're going to think about it, but you have no real certainty as to how they will decide their case. So you might say, if the primary advantage of arbitration is choosing your decision maker, why not just have the state pay for that guessing game? Just go to Superior Court, and whoever turns up will make the decision at the first instance, and you get a right of appeal to our Court of Appeal, which is an excellent body. Under the Arbitration Act, you don't get such a right of appeal. You end up going to a Superior Court judge from the Arbitration Act 1991, so you end up in front of the same person that you could have gotten in the first instance, and you don't have an automatic right to the Court of Appeal from that. But in any event, choosing the arbitrator will take a lot of your skill and background and knowledge of who's out there and how you think they're going to decide in relation to your case. In arbitrations, you will often develop or participate in streamlined procedures. And this can happen in the court process too. With a progressive judge, you can, by consent, agree to various procedures. But some of them that you will run into in arbitrations, you may well agree on time limits. And each side is constrained to put in his or her case in a particular time period. This means that the argumentative, meandering cross-examination you do at your peril, because it may prevent you from leading your case in chief sufficiently, and you may well sacrifice the part of your case where you prove it. Interruptions, lengthy in-trial motions, it's all on your nickel, so you're going to think twice in relation to what you do. It provides an amazing discipline on counsel. And when you see that the major issues of the day in the Supreme Court of Canada can be dealt with in an hour, you can see the possibility of having time limits in arbitrations to similarly get people to the point. Pre-filing evidence is very often done, and again, you can do this in court cases, but pre-filing your evidence in chief, you tell the whole story in writing. You attach all of the documents. I would recommend that you try and arrange the procedure so that you have an opportunity to do some limited oral examination in chief, rather than just putting your witness up as they do in the federal court for experts and just expose them to cross-examination. But if you can tell the essence of the story for a short period of time orally, have the full story documented in pre-filed evidence, that will save an enormous amount of time. Panels of witnesses. It's another thing that you will do, and you can do in court hearings as well with the permission of the judge, but can be done in arbitrations. It does hamper your cross-examination, and primarily because on re-examination, you can pick who you want to put your question to on cross, but on re-examination, the issue can be filled out by perhaps another member of the panel and blunt the effect of the cross-examination. So it may be only a certain kind of evidence that you'd want to lead by a panel. The rules of civil procedure are often agreed to apply. One counsel told me of a story where in his case they had agreed to do the arbitration in accordance with the rules of civil procedure, often done, and he moved for summary judgment. His opponent was completely shocked. He assumed he was going to an arbitration to have the whole case heard, but because this clause had been in the arbitration agreement, the summary judgment motion was granted, and that was the end of his arbitration. So think about it. You may or may not want to agree to that. Rules of evidence can be relaxed in arbitrations. That's something that is not done in court, so that's another advantage. Limits on discovery. Now, most of the discovery we do in civil cases is a total waste of time. We get thousands and thousands of documents. You have days and days of inquiry over those documents, and when you get to trial, you've got maybe a bundle of key documents, maybe 50 documents, maybe 150 questions out of thousands of questions that really count. So we do waste a lot of time on discovery, and in an arbitration you could agree on a more limited, if you can figure out a sensible limitation for the discovery. So skilled and experienced litigators who are familiar with the whole panoply of procedures, their advantages and disadvantages, can construct arbitration procedures to suit the needs of the matter. Let me talk about some of the innovative approaches on arbitrations that one sees. Mini trials. These are becoming popular among some clients because there are clients who are willing to sacrifice the efficiency, sacrifice the process in order to get a efficient and inexpensive process. They know they are sacrificing the prospect of finding that smoking gun in the bottom of, box number 49 of the productions. They know that they are, even by doing a mini trial, risking an adverse result if they can achieve significant efficiency and limit on expense. But even in very complex cases, you could agree to try the case in 2 days. Each side could be given a maximum of, say, 5 hours to put in their case in chief, a maximum of 2 hours to cross-examine on that case, and then a set time for argument. Clients who agree to this type of procedure recognize that they can win or lose because of this shortness of time, but they are willing to take that chance. Indeed, a group of large American companies with lots of intellectual property disputes have set up something called the National Patent Board. And the idea behind this is, instead of taking decades to deal with patent disputes, construction of the patent claims, and having the attendant uncertainty over their patent position for all that period of time, they will agree to go to this board, which is peopled by knowledgeable patent practitioners, and they will agree to one of these truncated procedures. The client who told me about a particular case recently that went all the way on was a construction of the patent case. He lost the case, but he was nevertheless most enthusiastic about the procedure because it had allowed his company to get a resolution of something that typically could take, when I say 10 years, I'm not exaggerating. And I know our next speaker can confirm that, having been involved in a 10-year piece of patent litigation. This client was, as I say, enthusiastic about the process, and he was impressed with his litigator, who typically would litigate these cases till the cows came home in the traditional fashion that we are sometimes want to do, and yet he was able to modify his usual procedures of deposing everybody and getting every document and taking a long time to present the case, and the client was extremely impressed with his flexibility. So here's where excellent counsel can thrive. Top barristers have always been capable of handling many different types of cases, from the preliminary hearings in the provincial court up to the Supreme Court of Canada and everything in between, and that flexibility of both style and approach, which top counsel have always exhibited, is the same kind of flexibility you can use to your advantage in these different procedures. Mediation, arbitration, med-arb, is another format you may run into. It's particularly unliked by the retired judges and others who have not come up through the mediation side of things, because understandably they gain knowledge as a mediator that they worry may affect their ability to dispassionately decide the case when they hear the admissible evidence. But there are some mediators who are very skilled at this form of ADR, and in the right case, it may provide an efficient way of dealing with it, because if you can't get to resolution through the mediation, you will at least have closure at the end of the piece. And in this kind of situation, you do have to have that flexibility, because on the one hand, you will be in mediation mode, and then you will have to switch to your more traditional contested proceeding advocacy. Arbitration mediation, ARB-med, is another variant where you arbitrate the issue first. You don't get a decision from your arbitrator, but you have exposed for both sides the strengths and weaknesses of each other's case. Then you move into the mediation, where people, it is assumed, will be more disposed to being realistic about the resolution of their matter. One variant I was told about was an arbitrator in Ottawa who arbitrated first, gave a decision for one side, then turned around and gave a decision for the other side, and then they went into mediation. Now, it's a lot of work for the arbitrator, but it was a very effective way of proving to both sides that there's always something to be gained by making the compromise. Now, an issue that is raised is whether we're losing precedence by having so much ADR, having so many issues resolved in this non-published private system. there are still many cases in the court system. There's administrative law, there's issues of public policy, there's constitutional law, class action, statutory interpretation. There's still lots of law being made. And if we think of ADR as just being another way to settle cases, and as trial lawyers and litigators, that is very much a primary goal of our segment of the profession, to try and get resolution for our clients, and the sooner we can get it and the more cheaply we can get it, the better we're doing our job. So if we think of this as just another way of settling cases, I don't think we have to lament the loss of precedent and worry that much about a second court system. So there's many challenges for us in practicing in both the courts and arbitration and mediation settings, but the essential skills of litigating can be used in these settings. And as clients increasingly turn to it, we have adapted and must continue to adapt to the requirements of successful lawyering in these differing arenas.
Questions? Yes, sir. I've never heard of a panel of witnesses. Can you explain how that works?
We actually did it in a case last year. It was in a reference in the court system, actually, and we put 3 witnesses in who'd all been involved in a manufacturing process, each from a different perspective. One had designed the machinery, the other one had run it, and the third one was quality control or something. And with the aid of we had a video that had a PowerPoint that had video feed in it, and so they were able to describe as in one piece, as opposed to the patchwork quilt format that you would have to do if you called each one to describe first the machinery, then the process, then the issues of quality control. They were able to describe the whole process by going back and forth among the witnesses.
Are you saying they all get up at the same time?
Yes. Yeah, they were known as the 3 tenors in our case, but.
In many trials, can they work in the ordinary court system?
Well,
Judges agree?
they have used them. I know Mr. Justice Farley has attended on our premises now and again and conducted a mini trial. I think that's more in his role of being the case manager and trying to get a resolution. In terms of, but you can agree to time limits on examinations and so on in the court system. In this very same case that I was talking about, we had agreed between counsel that we were told by the referee he was only sitting till December 15th or something like that, and if we didn't finish between September and December, he was out of there. So we had a lot of impetus to try and do it, and we just divided the time, and we kept a list of how long we were taking on our chief, our cross, on any in-trial motions, and just fit the case in. So it can, the time limit idea can be used in courts. I've been trying to use it in another case I've got on the go, and the case management judge is leery of it because he is worried, as always, about the Court of Appeal. Will he be criticized? To which I say, if counsel have agreed, then so be it. It's like a judicial admission. But there is that fear that you might run afoul of someone's right to be heard. So his preliminary thinking is not only will he get counsel to sign the agreement, but he wants the parties to agree that this procedure is acceptable. But I don't see anything wrong in principle if parties are over 21 or whatever the legal age is for making decisions like this.
Thank you very much to Sheila. It's my distinct honor to introduce our last speaker, the Honourable Mr. Justice Binnie from the Supreme Court of Canada. Rest assured, Mr. Justice Binnie, that I've read very carefully the recent promulgation from your court, and I will refrain, as it says here, from addressing you as my lord, my lady, your lordship, or your ladyship. I remain mystified as to why I still have to address justices of the peace as your worship, but perhaps we'll get that sorted out as well. As I'm sure everyone knows, Mr. Justice Binnie was, prior to joining the Supreme Court, a distinguished and one of Canada's leading counsel, and now a distinguished member of our Supreme Court of Canada. I was interested to see, as I looked back, to see what matters Mr. Justice Binnie had written on in his now approaching 3 years on the court, to see the very broad array of matters upon which Mr. Justice Binnie has written, including a fairly broad array of civil matters, always encouraging to us civil litigators who hope the court will take an interest in our leave applications. Some examples being significant decisions on commercial confidential information, loan defaults in the family farm, protection of school boards by virtue of limitation periods, liability for the misdeeds of our employees, probate fees, pension rights, and so forth. A very wide array of very interesting cases, in addition to the usual array of significant criminal decisions and other constitutional cases. So without more ado, I introduce Mr. Justice Binnie.
Thank you very much, Wendy. As to whether the Supreme Court is interested in civil litigation, I can assure you we're just thrilled to bits to get the invitation to talk to the first annual Civil Litigation Forum, because we are accused of being obsessed with public law and the Charter, and no doubt about 40% of our workload is the criminal work. But I'm here to tell you that we run a very user-friendly operation, and we want your business. So I thought what I would do is spend a few minutes just discussing how our operation works from the perspective of a civil litigator, and how you can play the system to your advantage. So I thought I'd talk initially a little bit about the leave application, because as Wendy says, well, why doesn't the Supreme Court take more civil cases? And I can explain without wasting too many words why there are so few civil cases on the Supreme Court. Actually, there are perhaps 30% civil cases, but there are many more that don't make it. I then want to talk a little bit about the materials and the process after you get leave, and finally about the hearing itself. The leave application, we get about 700 leave applications a year. And that sounds daunting because we grant leave in about 80 cases. We usually hear about 80 cases a year, 100 cases a year, 80 on leave, and 20 criminal as of right cases. So you say, well, you grant 80 out of 700, so the odds are heavy against leave on any kind of case. But you have to boil down that 700, because you can take about a third of them off the top. We get huge numbers of applications from Ottawa public servants who are dissatisfied with the Public Service Appeals Board and who feel, well, you know, this court down the road seems to hear stuff, so why don't we fire in an application? You get all kinds of litigants in person who've fired the lawyer because the lawyer lost, and they are now going to take over their own destiny and carry this through to the Supreme Court. And quite a number of those applications are actually handwritten, some of them very eloquent, but very few of them raising a legal issue. Then you get another third, I would say, of the leave applications, which are interesting, but are simply repetitive of points which the court has either dealt with fairly recently and therefore wants to see it work out through the system a little bit, or issues that are very well resolved in the jurisprudence across the country, and there are no conflicts between the provincial courts of appeal and so on. So when you really start to analyze this mound of 700 leave applications, at the end of the day, we are actively looking for cases as opposed to taking the view that we've got a full docket, how can we turn these people away? As Wendy said, I've been on the court now almost 3 years, and there has never been a case where there was an interesting leave application where we said, well, we've just got too much. We can't take it. On the contrary, there are points when we will go for a month or two and the well is so barren that you really wonder whether you're going to have enough interesting work to keep the operation functioning. So the problem is not in the court being receptive to leave applications, but of course the criteria is that the case raise a legal point of national interest. And a lot of that depends on the lawyer's ability to characterize what is the issue raised by the case. I mean, we have in the last year dealt with tendering processes. We've dealt with the rules dealing with contracts under seal, the duty of good faith in negotiating a lease, all kind. We've had 3 patent cases. When the patent cases were argued orally, the lawyers said, well, this is the first patent case the court has heard in 25 years. So at this rate, the next one will be in 2025. And Jack Major said, we'll be ready for it. Well, how do these cases get leave? The tendering process, all you have to do really is to say this is another Contract A and Contract B case. And there's such chaos surrounding Ron Engineering and the fallout for the last 15 years that the argument quite skillfully said, well, here's an opportunity to clarify everything. In the case of the renewal of the lease, it was really a very simple matter of an outraged landlord who'd been in negotiations, and the tenant walked away, leaving a large chunk of the building vacant. Doesn't sound very interesting, but it can be dressed up. You can talk about this. Is there a duty of good faith in negotiations? Well, most people would say no. There's no contract. There's no existing relationship like a trustee and a beneficiary or so on. So some wiseacre said, well, why don't I put the question, should there be a duty to negotiate in good faith in a lease arrangement which has endured over a considerable period of time? The patent cases, 2 of them dealt with washing machines, and 1 of them dealt with electromagnetotherapy machine. Not on the face of it, something that would grip the attention of the Supreme Court, but the lawyers for the washing machines said, hey, there's a case in the House of Lords called Katnick, decided by Lord Diplock in 1982, which is creating chaos out there. It's the worst decision ever rendered in a patent case, and all that stands between us and chaos is the Supreme Court taking this and clarifying the law. So, what was a humdrum case involving the agitator on a washing machine where it rotates and one part oscillates and one part rotates, was turned into this huge public law issue about conferring monopolies and how do you rein in the monopolist washing machine manufacturers and open it up to competition and so on. It just takes a little imagination, you know. I mean, in the 3 years I've been there, I would have gone through now 2,100 leave applications. When you see somebody who's obviously put a little thought into why we should find the case interesting, you're so grateful. You know, you tend to say, well, let's reward effort. Huh? Now, I say I read 2,100. How does the system work? Because it is important when you're formulating your leave applications to understand what the process is. The court is split into 3 panels of 3 judges. And in the first instance, the material goes to the panel, and the panel renders a decision within the court, either for or against, and quite often it's split. So then what happens is if a majority or the whole panel wants to grant leave, that decision goes to the entire court. No leave is granted without all 9 judges having an opportunity to view it, although obviously judges not on the panel defer to the greater amount of energy and work put into it by those who are on the panel. If there's a majority in favor of dismissing, but one judge wants to hear it, that goes to the entire court as well at a monthly conference where we consider the result of the leave applications. And even if the panel is unanimous in saying, we don't think this should be given leave, that decision is circulated to every judge on the court, and any judge can say, hey, I don't agree with the panel, I think we should hear it. And there are numerous instances where the court, the 9 judges sitting in the conference, will decide that we ought to hear a case after discussion that the original panel had turned down. So why is that process important? Well, it's important because when you prepare a leave application, you're addressing it to the 9 judges, because they all have to look at it at one point or another, who, in addition to dealing with the appeals, have this extra business on the side of the leave applications. And it used to be, you know, when they began the written leave applications, that lawyers would take, their unsuccessful outing in the Court of Appeal and slap a notice of motion on it and ship it to Ottawa. And it was felt at the time that going from oral leave applications to written leave applications was going to exponentially increase the number of leave applications simply because it was so easy to do. You just fire it in and you mail it to Ottawa. Since then, leave applications have become more and more complicated and cumbersome. And it's not unusual now to get a stack of material like that on a leave application. Well, it's crazy. I mean, it is physically impossible to get through 700 leave applications with that kind of material. We basically accept your word as to what the case is about. You know, if you get a reputation for not being forthright as to what the case is about, well, then that will count against you. But normally the assumption is lawyers are being straightforward and they're identifying what is the basis of the dispute and what is the common ground and why the issue is interesting. We're not really concerned with whether the case was rightly or wrongly decided in the Court of Appeal, because the function of the court as conceived since the Dixit era is one of sorting out the law and developing legal principles, not in correcting errors. So we are as likely to take a case where at first blush it looks like the Court of Appeal was correct as we are to take a case where it looks at first blush that the Court of Appeal was wrong. There is now an increasing tendency for people to file affidavits with leave applications. Somebody says, hey, judges, this is a really important question. Increasingly, we get affidavits from law professors saying, you know, you might not realize it, but I, Professor so-and-so, am here to tell you that this is an important case. Well, the rules governing leave applications say that affidavit if necessary. And there are occasions where it is necessary because, for example, a case years ago dealing with mortgage interest rates wasn't self-explanatory as to why the issue was important. And affidavits were filed, and the court understood that the ramifications of this decision were enormous. And I'm sure affidavits in that case assisted obtaining leave. But for the most part, we don't really care whether the affiant is telling us that it's an important case. Either the lawyer has succeeded in presenting it as an important issue or not. And if you're dealing with this number of applications over so many different areas of the law, your leave application turns on your success in defining an issue and putting enough spin on it that it looks like something that ought to occupy the 9 judges of the Supreme Court of Canada as one of only 80 cases on leave that will be heard that year. If you're responding to a leave application, again, so many people write a huge long screed about why the issue isn't interesting. Which, of course, is totally self-defeating. I mean, if it takes you 20 pages to try to explain that the case doesn't have anything to it, you've defined the opposite of the point that you're trying to make. So I think there are really only 2 ways of handling a response to a leave application. One is dismissive, you know, a page and a half. This is rubbish. Or to correct it. Say, you know, the applicant now says this is the point, but you got to realize that at the trial in the Court of Appeal it was never raised. You know, this is just an invention that's come in as a counsel of despair at the last moment. And when you get this case, you're going to find you never get to the interesting point because it falls apart on the facts at the starting line. Or you say, the applicant says that there's a division in the case law. You know, the Ontario Court of Appeal disagrees with the British Columbia Court of Appeal. Well, if you're responding, you say they don't disagree at all. These cases are easily reconcilable. The rule is this: there is an exception over here, which BC has addressed, but that doesn't undermine the efficacy of the well-established rule. So, yes, correct what you regard as errors in what has been put before the court by the applicant, but as soon as you get drawn into an argument as to whether the issue proposed by the applicant is right or wrong, then really you are undermining your own case. Just remember what's important: is it an interesting issue? All right. So you get leave. One interesting thing is some lawyers who get leave forget they have to file a notice of appeal. You know, you do have to, within 30 days, serve and file the notice of appeal, and then you get into preparation of the case on appeal. We had a case last month where the day before the appeal was being heard, one of the attorneys general filed 18 volumes of trial transcript. I guess they filed 20 copies. Each one of the judges got 18 volumes. on a case that was to be heard within 24 hours. The rule now, unlike some years ago, is that the appellant files a record and the respondent files a record. What is in the record is what is essential to the point that you're arguing. The case may have had 50 issues when you went to trial, and it may have had 10 issues when it went to the Court of Appeal, but when you get to the Supreme Court of Canada, there's probably one issue, or maybe two issues. And we're not really interested in the other 48 issues. All we want is that sliver of the record that is directly pertinent to the issue that you're going to argue. So, for the most part, even in a criminal case where there is a good deal of evidence going back and forth, the record should be maybe 1.5 inches or 2 inches thick. There should be a complete copy of the whole record filed with the registrar so that any judge who's concerned about some point can pursue it. But don't waste thousands of dollars of your client's money in preparing vast numbers of copies of material that in the nature of our particular court is of no real interest. If we want something, we'll ask for it. All right. The factum. I think what is essential to know about a factum in the Supreme Court is that it is your one chance to state without interruption, in your own words, what your argument is. Now, it is the habit of many counsel to say, well, you know, I don't have time really to prepare this case from stem to stern twice. You know, I'll put in a factum which more or less states what my argument is, and then my real preparation is before the oral hearing. Well, it's a disastrous policy because you've got 40 pages in which to attract the court's attention to the strengths of your case. The judges are going to read that in a leisurely way without all the heat and noise of a hearing. And it's going to form part not only of the questions they put to you, but you're setting up the questions you want to put to the other side. When you get to the oral hearing, we regard it, rightly or wrongly, as our chance to get to the bottom of the case. And while you're there to present argument, you're just as much there to answer our inquiries. And if your factum has not done the best it can possibly do in putting forward the whole of the argument on which you rely, then you've done your client a great disservice. I come back to the fact that there are generally, in these cases, one or two important issues. There is nothing more irritating than to sit down with a factum that compresses the whole of the appeal, most of which we're not interested in. You go through page after page of stuff which in the end you realize is of no significance at all to what the issue that we're being called upon to decide. Throws in dozens of cases without actually articulating a policy reason in support of the rule for which you are arguing, and tries to get around the 40-page limit by, you know, jamming the paragraphs, different fonts of type, compressing stuff, widening the, you know, or narrowing the margins. I mean, it's just totally self-defeating. The lawyer who really makes a favorable impression is somebody who comes in and says, this case is so simple and straightforward, I don't need 40 pages. Here's 15 pages, and that's the whole argument. And when I was at McCarthy's, I had the privilege from time to time to working with Mr. Robinette, John Robinette, in his work. I mean, he spent more time simplifying the argument than he did in trying to find support for it. And the objective, in his view, was at the end of the day, you can put your case on the back of an envelope. You can say, I've got, 2 propositions or 3 propositions. Here they are, and here's why they're correct. And the skill with which he maneuvered his way through the Supreme Court of Canada is legendary. But it's because he understood what the process is. We're not there to deal with every nook and cranny of the appeal. We're there to deal with the issues on which leave was granted. That's what we're interested in. And to the extent you go beyond that, you're essentially wasting your opportunity. The oral hearing. I think one thing that has surprised me is the extent to which people, lawyers, come into the Supreme Court of Canada without really having thought about the process and without having a very clear game plan. The Supreme Court of Canada is not another bite at the cherry that you missed in the Court of Appeal. It is a very different court, and it is a very different process. And I want just to outline 5 factors that you ought to pay attention to when you're focusing on the transition that has to be made between a Court of Appeal argument and a Supreme Court of Canada argument. First of all, in terms of complexity, there is an expectation that the higher you go in the system, the more sophisticated and complex the issues become. But that's not true. The Court of Appeal will be taking the raw product out of the trial division, which has been formed by the trial judge, but which still leaves counsel a huge range of issues to explore, including trying to upset findings of fact and so on and so forth. And it sheds, the vast majority of all of those issues and all of that material and all of that record. And a really well-argued case in the Supreme Court of Canada has the lawyer saying, look, here's your little role in this dispute, and it's about 4 inches by 3 inches. And all we're asking you, the Supreme Court of Canada, is the answer that, or is it this? So, although there's a limitation, as Sheila mentioned, of an hour in the Supreme Court for each party, the good lawyers don't take an hour, because the issues have become so concentrated and so focused after being through the pre-trial, the trial, the Court of Appeal, that you're really on the home stretch, and it's all down to quite a simple legal problem. It may have many ramifications. It may be difficult to get the right answer to, but it is a less complex proceeding than you will have already been through in the Court of Appeal. Preparation. I think the preparation in the Supreme Court of Canada is different than the Court of Appeal. We have many fewer cases, and by definition, we've already granted leave, so we think it's an important case. The judges in the Court of Appeal are not, because it's as of right to the Court of Appeal, they can't prepare every case in the way that we do, because a lot of it will be dealt with by endorsement, a lot of it will turn out to have very little merit, and you can only afford to commit so much in the way of judicial resources to appeals that may not go anywhere. in terms of the decision-making process. If you only have 3 judges, you can have a pretty informal discussion, which can be an ongoing discussion after the appeal is heard until the 3 of them either get together or agree to disagree. When you've got 9 judges, you're really locked into a decision-making format that requires that immediately after the oral hearing, the court convenes and there is a thorough discussion as to where each of the judges is coming from in terms of the ultimate result. So because I realize when I walk into the courtroom that within a few hours I'm going to have to give my views on what I think ought to happen in this case, my preparation has to be before the hearing. The hearing only takes half a day, so I don't have the time to soak it up while the argument is going on. And I've got to ask counsel questions on which I'm unsure, because if I don't get it then, I'm not going to have it by the time I've got to deliver my view as to what I think ought to be done. We have much greater resources in preparing than the Court of Appeal. We each have 3 law clerks. Every appeal will have 1 law clerk assigned to it by each judge. So there are 9 law clerks writing 9 bench memos for the 9 judges. And the level on which the preparation takes place, when you have a bench memo on each appeal, and you can say, well, I'd like more research on that point and what was the evidence on the next point, means that by the time that we come into the oral hearing, we ought to be prepared, and there's no reason not to be. So, you get to the oral hearing. It follows, I think, from what I have said, that the most important aspect of an argument in the Supreme Court of Canada is focus. It's true at any level of the court system, but it is nowhere more important than in the Supreme Court. And I suggest, if you take a submission that you would have made to the Court of Appeal of 3 hours, and you kind of throw away the first 2 hours, and you get down to the point in the Court of Appeal where you are really into the short strokes on the issue on which the case turns. That is the point at which you begin the argument in the Supreme Court. Because I venture to say, out of a 1-hour submission, you're guaranteed no more than maybe 15 minutes where you have control of what is transpiring. The other 45 minutes will either be spent on responding to questions, or it will be spent on chasing up a drift which the court is taking and which you had not anticipated, but which is clearly where the judges' heads are at in terms of what that appeal turns on, and you've got to go with the flow. So there is no point in coming into the hearing with a speech that has been written out and which you expect to read from first to last and which you've timed to last, 59 minutes and 30 seconds. You have to come in with a single piece of paper like that, right? And the single piece of paper allows you to maneuver in any direction that the questions and the debate on the court seems to be carrying the appeal, because you have to keep in mind that when the judges finish that oral hearing, they're going to walk out and they're going to be discussing this appeal and what ought to be done with it. So they don't have an opportunity to take 2 weeks to think it over and to realize that maybe the drift that they were taking is incorrect. Now, quite often down the road, opinions change the orientation changes, and the result is quite different from that anticipated at the court conference. But from your point of view as the lawyer, it seems to me that what is fundamental is your ability to be flexible, to react spontaneously to the movement of events, and to deal with those questions concisely and in a reasoned way. You know, not just cite old decisions and say, well, it was held by so-and-so this. I mean, if you've got a point to make, we want to know why you're making the point, what are the ramifications of the point, and why it ought to prevail. And the final point I would make, when you are arguing in the Supreme Court, by definition, there are two evenly balanced sides to the proposition. So there's no point in standing up and feeling that you cannot give ground, that your side is right, and no matter how thinly it seems to be spread under questioning, you feel you can't back off. The most effective argument, I think, is the lawyer who stands up and acknowledges the weaknesses in the case. I mean, no case is 100% one way or another. Certainly, if it was, it wouldn't be in the Supreme Court of Canada. So the lawyer who stands up and says, firstly, here's where the argument rests. This is what is basically common ground. This slice of the territory is in dispute. The problem with my case is this, but I'm going to tell you why that problem shouldn't govern the outcome of the appeal, and I'm going to tell you why, if the court wants to achieve a just result and a consistent result and so on and so forth, this is the way in which you have to reason your way to the conclusion and, in effect, spell out for the court what you, if you were writing the judgment, how you would formulate it and put it together. So, without laboring further on this process, what I did want to emphasize in talking to you is that the court is wide open to commercial work, but it's up to you to put it in such a way that attracts the attention of the court, and that when you get to the court, you appreciate that we function on a different timetable with a different rhythm than courts of appeal and trial courts, and the road to effective advocacy in the Supreme Court of Canada is to take those differences into account and work with them rather than be destroyed by them. So that's how to win in the Supreme Court. Thank you.
Well, I want to thank you, Justice Binnie. Those words are good advice, I suspect, not only in the Supreme Court of Canada, but throughout our courts. It's my distinct pleasure at this point to close. I want to thank everyone, again, Justice Binnie, for the very helpful thoughts. I do want to thank each and every one of the speakers. Their contribution was tremendous, and we really appreciate their taking time out of their very busy schedules. Obviously, I want to thank my co-chair, Wendy Matheson. And last but definitely not least, I want to thank everyone from the Law Society, and I'll mention specifically Paul Truster, Beverly Spencer, Kathy Castaldo, and finally I want to thank everyone who came and made this such a splendid two-day program. Thank you so very much.